So I think it's almost 6. We'll just have to stick to our time strictly.
Okay, sir.
We can finish early enough. We have so much to discuss today.
Wow, that is nice, sir.
Just 1 minute.
Okay, sir.
All right, so we're here. Good evening once again, everybody. Today we'll be having still an audit class, but we'll be having regulatory frameworks of auditing. To what extent is this relevant to the practice, to the audit practice? What is regulatory? When it is combined with framework, what does it mean? What are the examples of those regulatory frameworks? What is the expectation to auditors? What responsibility have auditors with respect to compliance with regulatory framework? Is there any statutory provisions or auditing standard that actually emphasize auditors' compliance with this? So these are some of the salient important facts we'll be discussing today. And I believe that at the end of this session, you will just be grateful you attended. But before we go on, let's do a quick recap of the session we have on audits class last week. Who can do us a quick reminder of what we considered last week? On this course, who can do us a quick reminder of what we considered last week?
Good evening.
Yeah, good evening.
This is Khadija. Khadija Lemon.
Oh, Khadija, good to have you.
Yes. Last week we did more like the introduction to assurance services. We started by defining assurance engagement. We spoke about the levels of assurance that you can give, reasonable and limited. Then we spoke about the
Ezekiel, please mute your mic. Is the noise coming from you?
No, the noise is not coming from my side.
Yeah, I'm referring to Ezekiel. I think the noise is coming from Ezekiel. Okay, go ahead, Khadija.
Okay, then we spoke about the elements of assurance services. We had the tri-party relationship between practitioner, responsible party, and intended user. Then we had the subject matter, the suitable criteria, sufficient and appropriate evidence, and assurance reports. Then we spoke about types of assurance services. The external audit, which is the statutory financial audit. The internal audit, reporting accountants, forensic services, investigation, review engagements, and so on. Then we spoke about the principles governing assurance engagement. That is professional skepticism, having a questioning mind, reasonable assurance, what the auditors are, the assurance practitioner are allowed to give, not allowed, like what they have the ability to give, because absolute assurances can only be given by God. Then audit risk and materiality, transparency and fairness. And we spoke about professional ethics, professional competence, which we are 5, sorry. Professional competence and due care, integrity, professional behavior, confidentiality, and objectivity. That was basically it.
Oh, thank you. But Khadija, I need to confirm from you. I hope you are not spying this from your book. Are you saying this offhand?
No. I add it to my head.
Okay, good. But that's a very good one. But what was the actual theme of the course we had last week? Who can put us to remembrance on that? What was the caption of the topic? What was the caption of the topic?
Assurance engagement.
No.
Okay.
Can anybody quickly remember?
Good evening, sir.
Good evening, Damilola.
Yes, sir. Nature, scope, and purpose of audit of assurance.
Exactly. That's
I
very
also want to
correct.
contribute. I also want to contribute that last week we talked about assurance. We talked about reasonable and limited assurance, and we learned that the major difference between limited and reasonable assurance is the extent at which the external auditor or maybe external accountant can work on a particular engagement. So in a case whereby his ability to work is limited with regard to our
Temilade, mute your mic, please. The noise is coming from you.
a platform to work based on the person available and to apply his professional experience and knowledge in a particular engagement. In that case, I expect that to be a reasonable assurance. Thank you, sir.
All right, thank you very much. You have all done well. So let's keep all our fingers crossed and hope to having a very enlightening section today. More importantly, today's topic is regulatory frameworks of auditing. You remember that when we had the session on financial reporting, we did add something relating to this, but it was with respect to accounting. So it is in the same light, we will consider the following caption in this topic. So of course, after we must have considered the basic introduction to regulatory frameworks of auditing, we will cite examples of a number of legal frameworks that has impact on audit practice. By that, we are referring to CAMA, Companies and Allied Matters Act. We will see the impact of the International Standard on Auditing, particularly ISA 250, I mean to say, the Insurance Act and NICOM guidelines, the Financial Reporting Council of Nigerian Act, that is of the Act of 2011, the SEC rules vis-a-vis the NSC Act, the Prudential Guidelines, International Standard on Auditing, Anti-Money Laundering Act, then Non-Compliance with Law and Regulation Act. So all of these are those things that actually impact how an auditor is expected to discharge his or her own professional responsibility. If you remember in our accounting class, we did emphasize that this regulatory framework are divided into various sections. One are statutes. Statutes are laws that have been made by the government of a particular state or country, which has impact on how accountant is to do their work. We have a similar portion of this that is also having impact on how auditors are expected to do their work. One of those statutes is the CAMA. CAMA is an encompassing document that cuts across most disciplines, right? It goes further to providing how the auditors, what are the responsibilities of auditors, who is actually qualified to be identified as auditors, and what are their rights and their obligations, right? Then we will also compare that with other various statutory provisions like the BOFIA, the Insurance Act, the NSC Act, and the likes. Then from time to time, some or all of these regulators in various industries give guidance to entities that operate within their sector. So you have various guidelines like the Prudential Guidelines and Guidelines are provided by NICOM from time to time. Guidelines are provided by SEC from time to time. Guidelines are provided by, by the FRCN from time to time. So we'll be having a look at each of these, and we'll also emphasize relevance of this to this practice of auditing and why accountants are expected not to only comply with this, but also be enlightening about what their obligations and their responsibilities should be. So we start with this. There is an urgent need to bring, okay, of course, everybody have an understanding of what this particular caption is. We are just reiterating the fact that we actually want to bridge the knowledge gap in practice among accountants such that our profession will not only be well respected, but people who practice it will also be reckoned with. So that's why we are doing what we are doing. Permit me to draw your attention to the following quotes by Lord Oliver of Hamilton. It is the auditor's function to ensure so far as possible that the financial information as to the company's affairs prepared by the directors accurately reflects the company's positions in order. In order, we state the order. So you will agree with me that auditors at every point in time, particularly when they are rendering their service in a capacity of an external auditor, are just affirming the correctness and the fairness of what the directors of various companies must have prepared. The auditors don't have the right or obligation to prepare any financials. Rather, their responsibility is to attest to what whoever that has those responsibility have done, whether that function has been discharged in line with the laws, in line with the guidelines, in line with the statutes, and in line with the various standards, right? So, in order first to protect the company itself from the consequence of undetected errors. So we as auditors don't only have responsibility to the external stakeholders, but primarily to the company itself. We want to be sure that disclosures and presentations in the financial statements are free from error, whether intentionally or unintentionally, right? We also want to be sure that to provide shareholders with reliable intelligence for the purpose of enabling them to scrutinize the conduct of the company's affairs. Please, if you're on the road, can you please mute your mic? Hello, if you're on the extra, please, if you're on the road, mute your mic, please. All right, so we have responsibility to ensuring that presentation made in the name of the company is free from errors, whether intentional or unintentional. Then the shareholders have reliable intelligence for the purpose of enabling them to scrutinize the conduct of the company's affairs. So it gives a level of comfort. What type of comfort now? Reasonable assurance to the shareholders that, oh, whoever that have been appointed to acting in their interest have discharged those responsibilities as expected of them. The legal requirements for preparing financial statements and an audit thereon is contained in the Companies and Allied Matters Act. So remember, we also emphasized it during the financial reporting class that ordinarily no one would wish to prepare financial statements if not that, among other reasons, that it is a compulsory responsibility as contained in CAMA. So also, CAMA goes further to also emphasize that companies, particularly those who are incorporated, should be audited by a certified auditor who, according to CAMA, is regarded as a professional auditor. We'll have this stressed out as we go on. There's still some noise from the background. Please, if you're on the road or you know that your environment's a bit noisy, please mute your mic. All right, so the financial statements are the primary mechanism for shareholders to monitor the performance of auditors. We all agree on this, right? I'm sure everybody agrees on that. So that being said, the audit thereon has an important stewardship role. So when the financial statements prepared by the directors are subsequently or eventually audited, it gives some level of confidence to whoever that wants to use that financial statement or information as contained therein, a higher level of comfort. And this level of comfort, we call it a reasonable assurance. Regulatory frameworks are legal mechanisms that exist on national or international level. So at the state level, at the national level, at the international level, certain precautions are given around how audit activities should be done, right? Which internal auditor, external auditor, or anybody acting in that capacity is expected to uphold. And that is what we are considering today. We are not just concerned about, auditors or accountants who knows the audit process, who knows how to identify risks, who knows how to perform all the relevant audit procedure, who knows how to set materiality and do various substance tests or substantive tests. No, but we, in addition to all those competencies, we expect that our auditors should not only be able to do all of that, but know the rules and regulations, laws that they are expected to uphold that could have impact on what they do. So they can be mandatory. Some of these frameworks are mandatory and cohesive, meaning that it is not optional. The moment you want to practice this particular discipline, it is your number one responsibility to uphold those values, right? And to ensure that you fulfill those responsibilities. Why is it compulsory? Because one, among other reasons, CAMA emphasizes it. So they can be mandatory or cohesive. That is, those national laws and regulations or contractual obligations are voluntary. Some of them are voluntary. We'll get to see those ones that are voluntary. For those ones that are voluntary, the auditor, Razak, please mute your mic. Razak, you are distracting us here. Mute your mic, please. All right, so for those ones that are voluntary, the auditor will then have the right to make his personal judgment, whether complying with it or upholding it or otherwise will in any way affect or influence misrepresentations of a material nature in the course of making its opinion. So together, they form a legal background against which anti-corruption efforts are measured. So, the act of stealing is not only what can be interpreted as corruption. When you should comply with certain provisions and such provisions are not complied with, it could be corruptive. So in this same context, we say, going further to espousing on what the true intent of regulatory framework is. So regulatory framework refers to the existence of necessary infrastructures which supports the control, the direction, and implementation of a proposed or adopted course of action, rule, principle, or law. So this infrastructure we are saying now is not the social infrastructure, but they are legal infrastructures. It cannot be seen with our eyes, but we should have the intellectual understanding of it and ensure that we act in adherence to the relevant provisions of the law, right? So that being said, you will also agree with me that to an extent, the work of an auditor looks very much like that of a lawyer, where you are expected to be able to uphold certain values, you are expected to be able to adhere strictly to certain provisions, you are expected to also spot where those provisions have been violated, to flag it and ensure that you do everything possible within the purview of your responsibility to drive the compliance of that, or assess if that non-compliance is allowed. Will it in any way affect the use or influence the use the user will have made of the financial statement? So the International Accounting Standard Board, IASB, issued a framework for the preparation and presentation of financial statements. This is referred as the conceptual framework. We did mention this before. The framework sets out the concepts that shape the preparation and presentation of financial statements for external users. All right, you will see that in this respect, there is a similarity between financial reporting and auditing, because the one starts from where the other ends. Financial reporting is the first one, then auditing goes further to uphold what has been enshrined in the financial statement. All right. So that being said, let's now go into the main context, right? We have before now explained the need or the meaning of regulatory framework as what? As those provisions, whether made by a substantive enactment, that is by any of the legislative arms of the government, or made by those that are saddled with the responsibility of administering the affairs of our accountancy profession in Nigeria, or made by those who are saddled with the responsibility of administering the business affairs in each sector of the Nigerian economy, right? All these put together, whether made within a country or internationally, as you will see later on, that auditors has a responsibility of assessing whether each entity they are auditing has an obligation to complying with those provisions. Where they have such responsibility, they must be able to assess whether they have actually complied with those responsibilities. Two, they will also have to report where there are exceptions to the compliance with those responsibilities. To what extent have those non-compliance, to what extent will it impact the opinion they will have given and the decision the users of the financial statement could have made with those financials? So now in specific now, some of those regulations or laws that auditors must assess and reassess in the course of their audit work are: one, Companies and Allied Matters Act. Prior to the very recent amendment to this, the prior one was, the latest prior one was in 2004, but was later amended in 2020. So everything we'll be saying in the context of this lecture will be that which is in line with that of 2020. All right, so the second one is the Professional Code of Conduct issued by ICANN. You agree with me that ICANN, by the enactment of 1965, is saddled among many other reasons, among many other responsibility, with the responsibility of ensuring the sanctity and the professionalism of the accountancy practice in Nigeria. So from time to time, they actually issue code of conduct that members, particularly those practicing who are in the industry are expected in practice, and those in the industry are expected to comply with, right? When I say those in the industry, I mean those who are acting in their various capacity as financial accountants and the like. There is still noise. Who is this? Please, can we check our various mic? Mute your mic, please. Noise is still coming from background. So it is the responsibility of ICANN to be able to sanitize that practice. So because of that, or as a tool to doing that, they have they from time to time issued what we call professional code of conduct. Then also we'll be looking at what is the composition of this professional code of conduct and how will it impact on audit practice. Then the next one is the Financial Reporting Council of Nigeria. This was introduced by the by the Act of 2011, right? Who is FRCN? What is their responsibility? How are they expected to discharge their responsibility? How will this impact the work of an auditor? It is important to say that, or let me put this as a question to the House. What was the former name of or a body that performs similar functions as that of FRCN before 2011?
NASB.
Okay, NASB means what?
National Accounting Standard Board.
Okay. What was the, are you sure it's National Accounting Standard
Sorry,
Board?
Nigerian Accounting Standard Board.
Nigerian Accounting Standard.
Okay, thank you. Among other responsibility, can you mention one germane responsibility of NABS then?
They are to issue accounting standard, which regulates accounting work, which is called Statement of Accounting Standards.
All right. So with effect from, please mute your mic. With effect from 2011, when the enactment, Ebuka, please mute your mic. There's a noise from your background. All right, so with effect from 2011, when this enactment was made, NAB ceased to be, even though it is on a similar structure and context, but it is now to be recognized as the Financial Reporting Council of Nigeria. Right? I think we might need to make a rule that anybody that we hear noise from his or her background without any authority will be delisted from this training. This is kind of distracting us. Please mute your mic if you are not to talk. Oluwatosin, do you want to say anything? I see your hands up.
Good evening, sir. Yes, sir. I actually wanted to suggest that as the admin, you can actually mute everyone. Then anyone that wants to talk, you can unmute the person. Because if you keep waiting for people to mute themselves, it will keep distracting you.
All right, thank you.
Thank you, sir.
Yeah. All right. Okay, so I was on the context of Financial Reporting Council of Nigeria, where I said it is a body that took over from NABS, the Nigerian Accounting Standard Board. Among other reasons or responsibility of NABS then, which transfuse into what FRCN is now to uphold, is issuance of the accounting standard in Nigeria. And everybody will agree with me that the accounting standard in Nigeria is the IFRS, which is formerly known as IAS. Beyond this, the issuance of accounting standard is presumably what most people know FRCN to be doing. But beyond that, they also do sanitization of the accounting practice alongside with ICANN. So they also do some supervisory role, trying to also ensure that audit procedures from time to time are done in the most professionally possible way, right? You'll be seeing how and what are those tools they use in the discharge of these responsibilities as we go on. So please just keep. Yeah, so we've mentioned what we have as Company and Allied Matters Act. We've mentioned the Professional Code of Conduct. We mentioned the FRCN Act. Then we've also, now we are to look at the Sectorial Code of Corporate Governance. Now, by the Sectorial Code of Corporate Governance, we mean that the whole economy of Nigeria is actually divided into various sectors, and each entity within each sector is expected.
Okay, I'll collect your number in case you see no work. Anyway, maybe today something.
And each entity within each sector is expected to, is subject to the ruling or the guidance of the regulator, right? Each of these regulators were actually brought to being by a substantive legislation. And the regulator, within the ambit of the legislation that brought them to being, issue guidance to its subject from time to time. So let's now look at some of those regulators and their subjects, right? That is what we put under the caption Sectorial Code of Corporate Governance. So the first of them is the Central Bank of Nigeria. You will agree with me that the Central Bank is a regulator of all entities operating within what we call the bank and other financial industry, right? The Central Bank was actually enacted, the Central Bank Act, the act that brought it to being, was an enactment, meaning it's a law made by the legislative arm. But discharge its responsibility within what is actually allowed to do in the act through what we call guidance from time to time and what we call the prudential guidelines, right? We'll be seeing this as we go on. Another very crucial sector are those entities that have their shares and other financial instruments being tradable on the stock exchange market. So everyone who have their share tradable on that platform is expected to adhere to what we call the SEC rules, right? And SEC rules was brought to being by the regulator called Security and Exchange Commission. This Security and Exchange Commission was also a product of a legislative enactment, right? Then the next one is the NSC, which works very much in line with the SEC. Then we have what we call the NICOM. NICOM, who can tell us the full meaning of NICOM? Please use the chat box. NICOM means what? NICOM means what? Full meaning of NICOM. Anyone? Don't tell me nobody understands the full meaning of NICOM. Khadija, are you there? Full meaning of NICOM. Abu Wahab. Ezekiel, what is the full meaning of NICOM? Okay, good. National Insurance Commission, very good, very good, very good, very good. So the National Insurance Commission is the regulator for all companies operating within the insurance industry. They also were brought to being by a substantive legislative act, right? But discharge their responsibility as regulator through the various guidelines that is being issued from time to time. So as auditors, we are expected to have a full and a good understanding of the provisions or the content of the acts that actually brought each of these industries to being. You also, in addition, need to know where any of those acts provide specific responsibility for the directors that have financial reporting obligations. Then you should also further find out if the enabling act or guidance issued from time to time also provide certain responsibilities for auditors that audit the financials of entities operating within a specific industry. So accounting profession, particularly in the capacity of an auditor, is more or less becoming like what in our secondary school days we will call the science student, because we used to think that, oh, all it takes for you to be an auditor or to be an accountant is just for you having a good understanding of the double entry principle. But you will agree with me now that the knowledge requirements for you to be able to perform competently it goes beyond your ability to know which account is to be debited and which account is to be credited. You need to know relevant provisions of the law as it impacts the industry of your client and as it impacts its processes. Without you being able to dissect these, you would not have been absolutely comply with the relevant provisions of ISA. It might interest you to know that these responsibilities are not just as contained in those various acts, but it's also upheld in the ISA 250, as we'll be looking at later on. So after this, we will be looking at each of these acts and how or which area of those acts are we expected to pay attention to. So the very first one is the Company and Allied Matters Act. It is said that Company and Allied Matters Act was recently amended in 2020. Citation in these slides were those as contained in the latest update. That is, everything we'll be making reference to here as regards CAMA will be as contained in the most recent update to CAMA. It may interest you to note that the Act is 7 parts or has 7 parts with 807 chapters in all. And these 807 chapters in all, or as divided into 7 parts, addresses different areas, right? But among all of these areas, some of these areas you need to know as a company secretary. Some of these areas you need to know as in your capacity as a director of a company. Some of these areas you need to know if you want to discharge corporate receivership or receivership functions. But what we are looking at today is you being an accountant and discharging your responsibility in the capacity of an auditor. What are the areas that interest you and that will actually help you in reaching a very objective opinion? Please, I want to be sure we are together and I'm not just alone. If you understand what I've explained thus far, can you indicate on the chat box with yes? Yeah. Okay, that's a good one. Then I also want to be sure that before we go into the nitty-gritty of this regulatory framework, I also want to be sure if anyone has any question at this junction. If you have a question at this junction based on what I've been explained thus far, now please indicate, or otherwise just indicate no on the chat box. If you have a question in what we have explained thus far, indicate, or otherwise just indicate no. All right, so that means we can go on. All right, good. So let's have a look at the very first one, which is the Companies and Allied Matters Act. While it is not out of place for you to be abreast of the provisions of this act, some sections are very relevant to your functions as external auditors. As auditors, you are expected to be informed of the provisions of at least Section 374 to Section 433, right? Section 374 of CAMA, from Section 374 to Section 433. These are the major areas. Other areas also relate to what you should be abreast of, but these are very germane areas that your ignorance of these as an external auditor will not be pardonable. So, but it is important to stress that time will not avail us to look at all of this. We will highlight these areas. We will discuss some of them. Then we will share, as we have always done, relevant documents or copies of each of these acts, which I will expect that you will take your time to go through and possibly engage us on questions. Unfortunately, I didn't see anybody asking any question based on what we have done before or last week. What that implies to me is that probably we didn't even have time, or we intentionally did not go through some of those materials that have been shared before. So please, everything we need to know cannot be dished out in this section within the limited time we have. But we will draw your attention to, we'll give you general or basic knowledge, but draw your attention to relevant documents that you need to personally go through for you to be abreast of what should be your responsibility and how you should discharge those responsibilities. So we start with Section 401. Section 401 talks about the appointment of an auditor. Who should be appointed as an auditor? Under what circumstance would somebody not qualify for appointment or reappointment, or would not qualify as an auditor? Every company shall, at each annual general meeting, appoint an auditor or auditors to audit the financial statements of the company, and to hold office from the conclusion of that until the conclusion of the next annual general meeting. My question is, since this particular section addresses when you are conducting your annual general meeting, that is the AGM, how will the auditor be appointed in the first year of business when, or prior to the holding of the first annual general meeting? How do you think auditors in that circumstance, on the first year of being in business, when the shareholders have not been assembled together to reaching a consensus on who they want to be appointed as the auditor, how will this function be discharged? Okay, Odeyemi said the the directors will appoint the auditor in the first year. Exactly, that's very correct. It may interest you to know that this responsibility is not just discharged by the auditor, by the director, but CAMA actually empowers the director to be able to appoint auditors in the very first year of being in business when that function cannot be discharged by the shareholders. Then secondly, aside the right to appointing auditors in the very first year of business by the directors, under what circumstance could the director also exercise this function? Under what circumstance could the directors also exercise the function of appointing auditors other than the very first year? Who can contribute in this regard? We recognize the fact that auditors could appoint, directors could appoint auditors in the first year. When could they also exercise this function? Okay, DME is saying that where there is a sudden vacancy before the general meeting. That is very correct. When there is a sudden vacancy, or when the outgoing or the substantive auditor is displaced or resigned for any reason best known, or when the existing auditor is actually late, or what we can call the sudden death of the auditor. That is very correct. So please, one common trait that we have seen in practice is that most people know what they ought to know with regards to some of these regulatory functions. But the problem we have found out is that when clients engage us as auditors or accountants and challenge the positions we have taken on various issues, we find it very difficult, or most people find it very difficult, to actually tie what their opinion is to substantive regulatory framework, right? And that's one of the takeouts I will expect everyone who is here today to take from here, that most of the things you know about your professional opinion, it is traceable to one law or guidelines or the other. So you need to take time to identify the source, the substantive provisions or sections of the law that from where you actually draws those your opinion from. So second thing is, at the annual general meeting, a retiring auditor, however appointed, shall be reappointed without any resolution being passed unless he is not qualified for reappointment, right? Under what circumstance could an auditor not be qualified for reappointment? Under what circumstance could an auditor not be qualified for reappointment? Anybody? Under what circumstance do you think an existing auditor may not be qualified for reappointment? Okay, Khadija says very good point. If the auditor is considered incapable, okay, yes. We've seen this in practice where a particular auditor has been auditing a particular company and the company grows beyond the national boundary, right? Let's say they grow into some other African countries or even other continents. And it is seen that the existing auditor do not have the professional competence to address the financial matters beyond the immediate local content. So in such instance, the auditor may be substituted. So this is a wake-up call for us as auditors, particularly those who actually administer their own firm, to look inward, because you may stand the chance of losing your clients if you don't sharpen your skills, particularly beyond what is obtainable in Nigeria. And that is the edge that most of those multinational audit firm has. So we actually can grow our competence and grow beyond or beyond the Nigerian market. Because as we pray that the businesses of our clients grows, most of the time they grow beyond Nigeria, and they will need auditors who will not only be abreast of the statutory responsibility in Nigeria, but also beyond Nigeria. So this may be a reason why one could actually lose or not be reappointed as auditor in the subsequent period. Somebody is also saying here that when the director considered that the auditor is not independent. Well, you are correct, but this is actually debatable, because you also, there may be some state of the skepticism that needs to be considered why that director is actually coming up with that. They need to be able to prove that beyond reasonable doubt, but it's a very valid point. Because sometimes the directors might just want to vote out the substantive independent auditor, particularly when red flags of their negligence have been identified. But when auditors are to be not to be reappointed or to be disqualified for any reason, they have the right to be aware of every proceedings that led or that will lead to their disqualification. So somebody said here two very important points. When the auditor is of unsound mind, very correct. We pray that we will never lose our sanity, right? Where such is found out, it could be a basis on the premise of which the auditor could be disqualified. Danjuma is saying here that when the auditor resigns his appointment due to audit threat, yeah, that is very correct, but the due process has to be followed. You need to exercise relevant provisions as expected in the law. But if you are resigning your engagement because of this, the law actually also provides, particularly as contained in ISA 250, that you should be able to outline what and those things that you have regarded as audit threats. You should be able to say it before that resignation will be accepted. So these are very salient points that we need to know, and we should keep up with this. Don't just let this content end here. Take the discussion further and make it as realistic as possible. Also use some of these salient facts you have here to make yourself more employable for those who are still within that sector. And for those who are doing the business of their own, use this as a way to tighten the loose ends in the course of you rendering services to your clients, or even putting your books together to be able to welcome auditors. So another reason is a resolution has been passed at the meeting appointing some other person instead of him, or providing expressly that he shall not be reappointed. So these are some of the reasons. We still go on in the next slide. Another reason is where he has given the company notice in writing of his unwillingness to be reappointed. But if the resignation is coming in this way from the auditor before the statutory period when he is not expected to be reappointed, that must be accompanied with reasons why he is unwilling to continue the engagement. What is for companies that are quoted, what is the minimum period before substitution that an auditor is expected to audit a particular client? What is the minimum period before statutorily the auditor should, or the partner in charge could be replaced? What is the minimum statutory period that an auditor can take up an appointment after which is expected to be substituted? Somebody says 10 years, somebody else says, Khadija says 7 years, or let me say 5 years. Can you tie any of these your positions to any guideline or law? Or I would like to hear from you, Khadija. Where do you get the concept of 7 years? I'm listening. Where do you get these submissions from? Why do you think it's 7 years? Are you drawing this from any law, from any guidelines, or what? Oh, you suppose it's just a recommendation? No, it should not be. Everything we do as auditor must actually be backed by a particular law. Let's look at it substantively. Do you think any auditor would not want to go on with an engagement, particularly when there is a fat returns from that engagement? So it then tells you that the reason for the cool-off period or the reason for the change must have been statutory. What is that law or what is that guidance that makes it compulsory for that audit function to be rotational? Yeah, Odemi, I agree also that one of the reasons for changing or rotating auditor is to boost public interest and the professional, yeah, or the profession as the case may be, yeah. But where is this idea coming from? So this will be an assignment for all. I will expect that before the end of this class, or during the question and answers session, we should bring this up again and actually trash that out. We don't, please bear it in mind and let it be a virtue that you must hold as a professional. Everything we do in our practice is actually enacted or encouraged by a particular law or some guidelines. So everything we do or when we make our decision, please always ask or find out, where is this custom coming from or decision coming from, or what is the backing for this? It's very important. Because I've seen in practice that I've had some clients that will always engage me and ask me certain questions or challenge certain authorities, saying they actually want to know where those submission is coming from. All right, so let's go on. Provided that where notice is given of an intended resolution to appoint some persons or persons in place of a retiring auditor, and by reason of the death, incapacity, or disqualification of that person, or all those persons as the case may be, the resolution cannot be proceeded with, and the retiring auditor shall not be automatically reappointed by virtue of this section. So we have looked at all of these provisions as contained in this section of the Act. That is section 401. And it says that it is according to the Act, not the voluntary intent of any company. According to the Act, an auditor must always be appointed and to do or discharge this function. It also provides instances where auditor will be appointed. What are those instances? We've stated it. Kenny, please, there is noise from your end. Please mute your mic. I tried to mute it here, it's not working. So that being said, please, let's go on. Try as much as possible to read more about that in section 401. All right, so number 3 of this says, where at the annual general meeting, no auditor are appointed or reappointed, the director may appoint a person to fill such vacancy. Penny, you are distracting us. I think I will start to start removing people that disturb us from now. All right, so the third one says where in a particular AGM, an auditor is due for replacement and the shareholders fails to exercise this responsibility, the directors could then exercise or fill up that vacancy. So that is summary of what we have in section 401. Section 403 talks about qualification of auditors. It tells you who should serve as auditors. It may interest you to note that while CAMA did not specifically state what should be the qualification of any auditor, it actually recognized the role of ICANN and every other institution saddled with this responsibility of training accountants or auditors to specifying from time to time what should be the qualification of an auditor. It is also a reason why you will not see in any section of the CAMA that an auditor should be an ACA holder or ANAN holder or FCA holder. It outrightly delegate that responsibility to the bodies saddled with the function of training accountants. So, and we can trace this to section 403. Section 403 says, subsection 1 of it, the provision of any act establishing a body of accountants shall have effect in relation to any investigation or audit for the purpose of this act. And none of the following person is qualified for appointment as auditors of a company. An officer or a servant of a company. Yes, you can be working in a company in any capacity, whether a cleaner, whether an accountant, a MD or whatever, and still be the auditor of that company. It's not possible. Your opinion will always be biased. So CAMA actually spoke to this directly. You cannot, if you're an officer of a company or you work in the company in any capacity, you cannot act as the auditor. Secondly, it says that a person who is a partner of or in the employment of an officer or a servant of the company, that could also not work. You can't have a partnership business and one of the partners say, we want to double as the auditor of the company. It's not possible. So also shareholders of any company cannot also double as the auditor of that company. A person who does not qualify for appointment, a person does not qualify for appointment as an auditor of a company if he or she is disqualified for appointment as auditor of any other body corporate, which is that company's subsidiary or holding company or a subsidiary of the company's holding company, or would be so disqualified if the body corporate were a company. Okay, this a bit what we can tie as a legal jargon. What does it mean? Let's put a scenario to this. ABC is the holding company of XYZ and PZ. Johnson Olaupa is the auditor of PZ, who was sacked or disqualified by PZ. ABC is calling for auditors, new auditors that could be considered for that appointment. Can Johnson Olaupa and Co. apply and be appointed as external auditor of ABC? Who has a response to that? No, why? Why? The no is correct because of the provisions of this. It said, if you have any company that is related to in any way, and you have been sacked as auditor by any of the subsidiary, right? You cannot, for any reason, be qualified for appointment by any member of that group, right? But if Johnson Olaopa has never acted in that capacity to any of the members of the entity, but was sacked or disqualified by a non-related entity. Can he apply and be appointed as the auditor of ABC? Will he then be qualified? Absolutely correct. Yes, he could be qualified if provided that all the parties to that appointment or confirmation of that appointment is actually convinced that he can act and he has the requisite qualification and competence. That's very correct. So second one is a debtor to a company or to a company that is deemed to be related to the company by virtue of interest in shares in an amount exceeding 500,000. Okay, please, this is also to be interpreted with caution. Johnson Olaopa & Co. is a professional firm of chartered accountants. ABC PLC is calling for new auditors, but it was found out that Johnson Olaopa & Co. had once taken a loan of 10 million from ABC PLC. At that date of consideration for the appointment, can he act as auditor to ABC PLC? Okay, why? Why do you say no? Why do you say no? Oh, somebody said, okay, Opayemi said his debt is more than 500,000. Oh, okay, please look at what they are saying. No. A debtor to the company or to a company that is deemed to be related to the company by virtue of interest in shares, right? So if you're a debtor to a company, you are not qualified to act as an auditor because your opinion is likely or is most likely to be biased. All right, yes. That's correct. So let's look at the next one. A shareholder or a spouse of the shareholder of a company whose employee is an officer of the company, right? So in this context, if Johnson Olaopa & Co. is the partner of the firm, has a wife who is an employee to ABC PLC, can his application or appointment be considered as external auditor to ABC PLC? Okay, the answer is still no. No. All right. That is technically correct. So that's what you can see is interesting if you look at each and every of
them. I have a question, please.
Okay.
So in the last statement, does it mean that if the spouse is an employee but not in a management position to influence the company decision, he still can allow Toago can still not take that job?
Yeah, you need to be able to appraise and reappraise the extent to which that his opinion may be influenced. Let me give you a practical scenario. So in practice, we learned of an auditor whose husband is actually an employee of a company, right? That she's auditing, and the employee is never in a capacity to influence or be in a position to be able to influence the content of the financial statements. But there comes a scenario when the chief accountant of that company wants the auditor to actually compromise, right? And there was a threat. There was a threat that if the auditor did not compromise or adhere to what they have proposed to her, the employment of the spouse will be terminated, right? And the compensation from the employment of the spouse is actually very bogus. What would you do in that capacity?
Now again.
So you can see that the interpretation of ability to be able to influence is not only tied to you being in that position to be able to change numbers, but you being or your spouse being in a position where it can be used as a way to influence you to dance into their tune. Do you agree?
Yes, absolutely.
So as auditors, from time to time, we need to be able to appraise and reappraise circumstance that could make you actually not being able to be objective as you ought to be. All right, so let's look at section 407. I'm just trying to skip them because there are so many and the time will not permit us to look at everything. But please, I'll encourage you to take your time to look at every other relevant sections of these laws. It is very interesting if you look at them in this way and try to put a case around it. That will further strengthen your understanding of it. So section 407. Okay, somebody has a question?
Yes, sir. Damilola.
Okay, Damilola, go ahead.
Based on your earlier explanation, from the last explanation, I've been able to understand that if an auditor and an auditor in particular have any related part in the company, I think the best bet is not to take on the business because it may be very hard for you to establish the fact that the person in charge may not be able to access your information. But I want to ask that from practice, in the case where for the example you just give us now, the woman which is an external auditor and an husband who is an employer of that company, and is it clear that the external auditor does not compromise and she is doing the right thing, for there's an audit threat from the organization to start her husband? In the case where there is a fact and figure to back up that there's a threat on the side of an external auditor, is it punishable under the law in the practical aspect?
Yeah, it is actually possible if you have your substantive evidence, but there are two different cases. You will have to do what is needful on your own side as the auditor and ensure that you fulfill your own obligation and your opinion is unbiased. Then you wait for the worst. The worst is then that the spouse concerned is sacked. So you can then put up allegations with relevant points, but you need to be sure that the spouse has not been in a position that will make him or her to have been sacked. Because if you want to be able, there is a caveat that says that he who seeks justice must come with clean hands. So if at any point you don't have skeleton in your cupboard and you think the spouse has done everything reasonable as expected of it, then you can also push the case and sue it and get redress. Do you understand? Yeah. Sorry, just give me a minute. I want Hello, sorry, I'm back. I'm so sorry. Little distraction. I just decided to quickly power the gen. Please, are we all there? Please indicate hi if you are there, please. Awesome. All right, so we can go on.
Very slow.
All right, so we've looked at the section 401, we've looked at section 403, we've also looked at section, we are now to look at section 407, right? Now, this is talking about auditors' duties and powers. The company's auditor shall, in preparing their reports, carry out such investigations as may enable them to form an opinion where or whether proper accounting records have been kept by the company and proper returns adequate for their audit have been received from branches not visited by them. So you will see that this particular thing is also re-emphasized in the ESAs, right? The relevant ESAs, particularly trying to buttress what the attention of the auditors should be. But it is also interesting to also note that CAMA also further buttresses this. So if the auditor complete the audit process without making this affirmation that adequate records have been kept and returns due from all branches, particularly those ones they could not visit, right, has been obtained, then that auditor has failed in its responsibility. Then the B of it says, the company's balance sheet and its profit and loss account are in agreement with the accounting records and returns. So your function as auditor also includes that there should be correlations between disclosures in the balance sheets as it is expected to flow from or to the profit or loss account. While the CAMA did not tell you how to make disclosures, how to identify what is an asset, liabilities, capital, reserves, what is a qualifying capital expenditure or not, and how to making your tax computations and the like. The CAMA did not tell you anything about that. It has delegated that responsibility to ICANS and every other accounting regulatory body. But it only says that, oh, whatsoever you have disclosed as balance sheets must be reconcilable to your profit or loss account, and auditors must reaffirm this. Then if the auditor are of the opinion that the proper accounting records have not been received from the branches, not visited by them, or if the balance sheet and the profit or loss account are not in agreement with the accounting records and returns, the auditor shall state the fact in their report. So you need to state it, right? But you also need to be able to know what is the form of your audit opinion. Much later on, you'll be seeing where, in what type of engagement do you give a positive opinion? And in what type of an engagement do you give a negative opinion? What is a negative opinion and what is a positive opinion? We'll be looking at that in our subsequent classes. But note that when all is well, all returns has been obtained, confirmation has to be, given. When all is not well and confirmation has not been obtained, right, you should also affirm this in your opinion. Every auditor of a company has a right of access at all times to the company's books, accounts, and vouchers, and be entitled to require from the company's office such information and explanation as it thinks necessary for the performance of its audit duties. So this is also the right that the CAMA has actually accorded onto the auditors, and you must leave. You know, when the purpose of a thing is not known, abuse is inevitable. If you are not abreast with what your responsibilities should be, how would you be able to demand it when it has been deprived of you? So that's also emphasized need why, as auditors, we need to go not just on CAMA, but as contained in every enactment that relates to the company you are auditing. So if you are auditing a microfinance bank, you should not only be aware of the content of CAMA, but the relevant guidelines are that CBN issue from time to time having impact on microfinance bank. If you are auditing a money lending business is not subject to control of CBN, but each of the states where this particular company or entity operate from, the state have standards that they also adhere to. And that is also to be measured or assessed in line with the requisite accounting standards that may be applicable, right? So please, you will do yourself a lot of honor when you are not just auditor by pen, but auditor that knows what the law says and identifies responsibility and discharges those responsibilities in line with the expected. So the auditor shall consider whether the information contained in the director's report for the year for which the accounts are prepared is consistent with those accounts, and if they are of the opinion that it is not, they shall state the facts in their report. Who is tampering with my screen?
Okay.
Then section 409 talks about removal of auditors. Under what circumstance can we remove auditors? A company may, by ordinary resolution, remove an auditor before the expiration of his term, notwithstanding anything in agreement between it and the auditor. So if for any reason they find that to their own satisfaction, they are not comfortable with the auditor, they can remove the auditor. But the auditor has a right to be aware of all allegations brought against it. Then where a resolution removing an auditor is passed at the annual general meeting of a company, the company shall within 14 days give notice of that fact in the prescribed form to the commission, right? Who is the commission in this context? That is the CAC. And if a company fails to give notice required by this subsection, the company and each officer of the company are liable to the penalty as the commission shall prescribe in its regulations. So this also tells you that having an understanding of the provisions of CAMA is not enough. You should also be abreast of the various regulations that CAC may dish out from time to time. All right, so this is the one that addresses resignation. That is when the auditor has a right or may choose to resign as opposed to it being relieved of its engagement. We will share these slides. Time will not permit me to go through everything because we still have a lot of things that have not been considered, right? Please allow me to just speed up because of time. So we've looked at some of the relevant areas of CAMA. What you are expected to do is to take your time. We will share a copy of the CAMA, the most recent version of the CAMA with everybody. We will also share a copy of these slides that you can go through at your convenience, alongside with every other enactment that we shall consider in the course of this class, right? You are not expected to read this as you read your regular novels. No. You are expected to apply them, whether when you have first of all, have a general knowledge. It's good for you to have a general knowledge. But when you now have an engagement that relates to each of these acts, make sure that as part of your preparation towards the commencement of that very engagement, you need to read the aspects of that act that relate to your own responsibility. Then if you are working in a particular industry and you are not abreast of the acts or guidelines that regulate the affairs of operators in that industry, then you are doing yourself a lot of disservice. So you don't just say, oh, it is the auditor that has this responsibility. But if you are acting in the capacity of a financial accountant, you also need to know those responsibilities, because the auditors, when you fail in discharging yours, you will, and the auditors will then spotlight it and recommend you for sanctions, right? But it will also do you a lot of favor when you don't only know your own responsibility, but also know the responsibility of the auditors. When they come up with the discharge of those responsibilities, you appreciate and assist them in the attainment of the set target. So the next second one we'll be looking at is the Insurance Act. Insurance Act is not applicable to any company that is outside the insurance sector, or any company that is not any insurance company that is not operating in Nigeria, right? And just as we said that the regulator for entities operating in the bank and other financial industry is the CBN, the regulator for entities that operate within the insurance sector is the NICOM. So in addition to the Insurance Act, there is also regular regulations relating or as introduced by NICOM. Please, can anybody confirm what is the recent or most recent standards, accounting standards, that relates to insurance business in Nigeria?
I think that is IFRS, just for insurance contract.
IFRS what?
I think IFRS 14 or so.
No, it's not IFRS 14. The most recent one. The most recent one, anybody?
IFRS 17.
Very correct, IFRS 17. Right? It is IFRS 17. So everybody needs to be abreast of this. You know, the provisions of the standard does not say it is only insurance companies that it impacts, but everybody that has an insurance contract could be impacted by that standard. So please take your time to read through all of this. Now, if you work in an audit firm and you have clients in this insurance sector, or you work in an insurance sector your own, or you are proposing to changing your job, so going into an insurance industry, please, part of the ways you can actually prepare yourself to being employable is not only to know how to prepare the financials, but to know the laws that has impact on insurance business, right? Know the various regulations or guidelines that is being introduced from time to time. All right, so Insurance Act. Insurance Act was enacted and applicable to all business, insurance business, and insurers other than businesses carried on or by insurers of the following descriptions. Remember at my introduction, I said, this Act has impact on all insurance business in Nigeria. So if you have insurance company that are not Nigerian entity, it may not have an impact on them, right? So what are those other scenarios or events that could happen in Nigeria or entities you can have in Nigeria that this Insurance Act is not impacted upon, even though their processes may look like an insurance business? One, a friendly society that is an association of persons established with no share for the purpose of aiding its members or their dependents, where such association does not employ any person whose main occupation is the canvassing of other persons to becoming member of the association. Two, is in the collecting of contributions or subscription towards the funds of the association from its members. So if you have any friendly society that is in the business of canvassing others to become members of its association and that collects contributions or subscription towards the fund of the association from its members, it could then be impacted by this act, right? So if you don't have any person that is specifically employed to do any of these two things or other things we may look at later on, then you don't have an impact. So you can see that the Insurance Act is not only having an impact on insurance business. If you work as the accountant or treasurer of an association and you employ somebody to be chasing your members, right? To chasing your members to making their contributions or their subscriptions, or you have an impact, you have a dedicated desk that canvas people to actually join you, then you will have been impacted by this Insurance Act. So let's put a scenario around that. Imagine ICANN as an association has a dedicated desk that from time to time canvas people to joining it, and also has a dedicated desk that chases members to ensure that they pay their subscription from time to time. Will it have been impacted or subject to the provisions of this act or not? Yes or no? Unfortunately, if they have a dedicated desk that chase people to paying their subscription, right? And a dedicated desk that canvas people to joining them, they are subject, because that is what the law says. Let's read the law again. A friendly society that is an association of persons established with no share, right? ICANN has no share, for the purpose of aiding its members or their dependents where the association does not employ. So if it employs persons, even though it's an association, but employs persons to canvas members to join in it and have a dedicated desk that chase people aggressively or to paying their subscription, it will then be impacted by the provisions of this standard, even though they are not an insurance company. That's what the Act says. That's what the Act says. So please, so we need to, you see now that it's very relevant for us to go through these things and ensure that we are equipped with the right understanding. A company or anybody, any other body, whether corporate or unincorporated, or persons whose business is established outside Nigeria, engage solely in reinsurance transactions with an insurer authorized or pursuant to the provisions of this Act to carry on any class of insurance business. So this is another party, but let's put a scenario to this. An incorporated entity is a company that has been incorporated or registered with the CAC. An unincorporated entity can still be a registered business name, a partnership, or just an individual, right? So let's assume that we have an insurance company that is based in Ghana, but they now have a branch in Nigeria. Will they be impacted by the Insurance Act or not? Will they be impacted by the Insurance Act or not? Yes or no?
Yes.
I'll take that scenario again. We have a big insurance business that their primary location is in Ghana. It is owned by Ghanaians. They have decided to expand into Nigerian markets. They have a business in Nigeria. Will they be impacted by this Insurance Act? Very correct, yes, right? But if you have that same scenario, and the business of the company is a reinsurance business, and their responsibility is not, it's not tied to Nigeria, they are not expected to be impacted by this because they are not in Nigeria, they operate outside Nigeria, and that is why they should not be impacted.
Yes.
So the Act is divided into 14 parts. Remember, we said the CAMA was divided into 7 parts, but the Insurance Act was divided into 14 parts with 103 chapters. Who can remind us, how many chapters do we have in CAMA, the recent CAMA? I stated in my previous slide. How many?
7 parts.
7 parts, but how many chapters?
807 chapters.
All right, thank you. All right, so the act is made up of the purpose of, is made for 2 purposes. 1, to address the life insurance business and to address the general insurance business, right? So please, even if you're a tax consultant and you have clients in this sector, it is still very important for you to be abreast of this. So in the case of a life insurance business, there are 3 categories: individual life insurance business, group life insurance, and pension business, health insurance business, right? These are all life-related insurance policies. So it tells you that all of these HMOs you are seeing around, they are actually subject to the Insurance Act. True or false?
True.
True or false?
True.
True, very good. So why? If you have been working or you have been auditing a company who is an HMO or who is offering an HMO related service, and you are not abreast of what the Insurance Act has provided, then it means you are not doing the right thing. Please, you notice I keep on emphasizing and re-emphasizing this. In the case of general business, there shall be 8 categories. 1, fire insurance business. 2, general accident insurance business. Motor vehicle insurance business. Marine and aviation insurance business. Oil and gas insurance business. Engineering insurance business. Bond credit guarantee and surety ship insurance business. Miscellaneous insurance business. So all of these set of businesses, when it is done, they are expected not to only register with the CAC, but also to be subject to NICOM rules and regulations and adhere strictly to the Insurance Act. NICOM is the National Insurance Commission and is a regulatory body for insurance companies in Nigeria. And it is tasked with the function of effectively regulating, supervising, and developing the Nigerian insurance industry for the protection of insurance consumers and other stakeholders. What is the ministry in charge of insurance affairs in Nigeria? Do you have a ministry, a government ministry for insurance in Nigeria?
Yes.
What is the ministry called?
Yes.
What is the ministry called? You have a Ministry of Insurance, not NDICU. It's not NDICU. It's Ministry of Insurance. You actually have a Minister of Insurance, right?
Yes.
That also work hand in hand with NICOM and all the all the companies or entities within that industry. It is that ministry that have also pilots the strict adherence and implementation of IFRS 17. Please, you need to be abreast of all of this information. An accountant that is not informed is not a professional accountant. For you to be regarded as a professional accountant, you need to be well informed about happenings in the economy, not just in your industry, but in the economy where you operate from. It's not Ministry of Finance, it's Ministry of Insurance.
Ministry of Insurance, Dion.
Yeah. You can double check. All right, so it is therefore important that as auditors, financial accountants, and tax consultants that renders professional service to clients within this sector, they must be aware or have fair working knowledge of the industry. The first step So the first step to this is to familiarize yourself with the regulatory framework, including the laws that are relevant to the insurance sector. So time will also not permit us to look into the section by section provisions of Insurance Act. But as we promised, we will share the copy of this act, and you are encouraged to go through this act at your leisure. If you have any areas of ambiguity, let's engage each other, or possibly engage me, so that we can have clarity to areas of misconception. All right, so another area that is very relevant for us is international standards on auditing. I told you that these regulatory framework are into two, the legal framework and the standards. So we have considered some of those standards. We are also looking at, and we have considered some of those laws. We are now looking at the standards. The international standard on auditing are professional standards for the auditing of financial information. These standards are issued by the International Federation of Accountants through the International Auditing and Assurance Standard Board. So bear it at the back of your mind that every time we talk about ISA, International Standard on Auditing, it is issued primarily by IFAC through one of their departments, which we call the IAASB, right? The International Auditing and Assurance Standard Board. The FRCN render some function in this regard. They have tried from time to time to amend some of these, localize some of these provisions of the standards. So we don't forget, in addition to the international standard on auditing, we also have the NSA. What is NSA? What is NSA? NSA means Nigerian Standards on Auditing, right? We also have the Nigerian Standard on Auditing. Please take your time to go through this, and it is also expected to be issued by the FRCN. So ISA provides guidance to the auditor on how to harden value to their engagements, and by default building confidence of investors, right? So ISA has not gone to doing anything other than ensuring that guidance are provided on how the auditors are to address various concerns of the audit processes, beginning from what should be your objective when you are doing or taking up an independent audit engagement that is addressed by ISA 200. There is ISA 210 that talks about a different thing. There is ISA 220 that talks about quality control. There is ISA 230 and all of those. So each of those ISA actually addresses each and every unique function among the audit process. So I encourage you, please take your time to going through all of this. The standard covers various areas of auditing, including respective responsibilities, audit planning, internal control, audit evidence, using the work of an expert, audit conclusions, and audit reports, and standards for specialized areas. Among all these ISAs, ISA 250, that is consideration of law and regulations, regulations in an audit of financial statements. This is one of the ISA that actually emphasize that as external auditor or as auditor, when you are performing your audit process, you need to give or provide due consideration to the laws and regulations in the audit of that financial statement of the company that you are auditing. If you fail to keep abreast of this deliverable, it means that you cannot conclude that the audit has been concluded or conducted in line with the provisions of ISAs. So ISA 250 imposes the responsibility on auditors to ensure that due attention is paid to laws and regulations which could have impact on the auditee's business process and by extension on the presentation and disclosures in the subject matter. In our last class, what do we regard to as subject matter? In our last class, what do we regard to as subject matter? What is subject matter?
Financial statements.
Exactly, the financial statement. And also in our last class, we regard the subject matter as one of dash. One of dash. It is one of what?
Element.
Exactly, the elements of an assurance engagement. So please, I hope these informations we had value to you. ISA 250 redrafted stipulates that the auditor's responsibility to consider laws and regulations pertinent to an audit client in an audit of the financial statement. Some laws and regulations have a direct effect on the financial statement. For example, in Nigeria, the Company Act of 2020, that is the CAMA, has a direct effect on the financial statement. Then other laws and regulations do not have a direct effect on the financial statement, but may instead have a direct effect on how the entity conducts its business, right? Most of the provisions in the other guidelines given by the regulators would not have direct impact on the financial statement, but the process during which each of the operatives perform their various operations. An example of such a law could be the Health and Safety at Work Act in Nigeria. Other industries may operate in heavily regulated industries, such as banks, insurance, and so on. So please, somehow we say audits may be too theoretical because there are so many, some parts of it, not all, because so many areas of it are addressed or tied to one law or regulation or the other. But I hope it is interesting. I hope what we are discussing today is interesting. Yes or no?
Yes.
All right, so the auditor needs to consider laws and regulations pertinent to the client because a breach in such law may result in fine and other consequence which may have a material effect on the financial statement. This is what I have observed among so many auditors. They pay so much attention to the disclosures and the financials, right? And pay little or no attention to regulatory provisions that is expected to be adhered to by the companies. Say, for example, if you have a company that is a microfinance entity or bank, what is the deadline for filing the accounts, audited accounts of microfinance bank with the CBA? What is the statutory deadline? Who is aware? Just like we have in tax, every company is expected to file returns with the CAC, with the FIRS, not later than 6 months after the financial year end. Operators as microfinance bank are expected to file in their accounts with their regulator, who is the CBA. What is the statutory period or deadline which they are expected to file in these returns? If we don't know, it means we are not paying due attention. Okay, Obasi just confirmed that 31st of March of the preceding year. No, it is the following year, not preceding. No. Preceding means before. So except you say 31st of March of the preceding accounting year. I mean, of the preceding account. So when you say account of 2021 now, it's expected to have been filed with the CBN not later than 31st of March of 2022. So that is not preceding year. Is that clear? Then when you, let's now identify the, okay, let's now identify the relevance of this singular information. What is the penalty for not filing the returns with CBN at the due date? What is the penalty? Who is aware? What is the penalty? What is the penalty? Who is aware? No response. So imagine that you are completing an account. You have audited the account. The company has breached the statutory period, and you did not make provisions for this penalty or fines that could have been imposed on the defaulting company. So it means your financials that you have audited does not reflect true and fair view as at the year end or as at the date the account was signed. So this order emphasizes one of the reasons why we need to pay attention to the various laws. Somebody is asking, can an outgoing auditor sue an incoming auditor for the failure to comply with professional courtesy? No, you cannot sue anybody. But if you have any professional negligence against your fellow professional accountant or auditor, you can, first of all, what expected is that you approach the person first. And if the person did not take to caution, you can then report to ICANN, who is the regulator. Before you can sue anybody, you must have been able to justify that the action or inaction of that person, you have suffered a direct cost or liability from it. Otherwise, you will not be able to sue, make a case in that regard. Responsibility for ensuring that the entities complies with all the laws and regulations applicable to its rests with the management and those charged with the with governance. But the fact that it is the responsibility of the management does not absolve you as auditor the responsibility of monitoring and ensuring that what is expected to be done by the management and those charged with governance has been fully complied with. Then the auditor's responsibility is to identify any non-compliance of laws and regulations which may result in material misstatement with this financial statement. The auditor does not have the responsibility to detect non-compliance with law and regulations, and when an act constitutes a non-compliance is a matter of a court of law to determine, right? So that is what you need to know within the purview of ISA, but please, we will share ISA 250 with you. Take your time, in addition to other ones we have shared before now, to go through them and ask questions where you so desire. So another area is the Financial Reporting Council of Nigeria. We'll talk about this. We've said that it was formerly known as NABS, but subsequently in 2011, changed to FRCN and has the same responsibility as that of NABS. In addition to their formal responsibility, they are also to check the rate of professionalism within the accountancy space and the audit space, right? They also issue from time to time Nigerian standards on auditing and check the practice of various audit firms to be sure that they are doing what they ought to have done as it is expected of them. So for you to understand fully how the processes of Financial Reporting Council of Nigeria will impact your work as auditors, you need to have an understanding of the content of the FRCN Act of 2011 and the FRCN rules. FRCN issues rules from time to time. So to date, they have 8 rules. They have Rule 1, Rule 2 to 8. Rule 1 talks about the Financial Reporting Council certification requirements for chief executive officers and CFOs. So if you are the CFOs or CEOs of any company, by Rule 1, you are expected to be registered with FRCN. Rule 2, Financial Reporting Council. So before I go there, so if you as auditor is auditing the financials of a company and their CFO and their CEO does not have, who has responsibility to signing accounts, does not have evidence of registration with FRCN, then you should query that process. You need to recommend that FRCN Rule 1 code provides that they should be registered. I've been checking various accounts prepared by most of the small size or the medium, small size account audit firms, and I observed that these numbers some have been disclosing, but some majority have not been disclosing. So please, it's an area that you need to take back to your firm and ensure that those who has a responsibility for signing accounts are duly registered with the FRCN. It may interest you to know that among our regulatory services, should you have anyone that you want to register for this process, we can actually help you completing this process. We do that as part of our regulatory service. So Financial Reporting Council certification requirement for professionals engaged in financial reporting process, whether as accountants, as external auditors, as tax consultants. The moment you are rendering your service in a professional capacity that impacts the financial reporting process, you should also be registered with the FRCN. So if you are an auditor that signs your accounts without referencing your FRCN registration number, then you are violating the provision of this code and you could be sanctioned. Then Rule 3 talks about provisions of audit and non-audit service. So this rule actually says that when you are auditing any entity, so when you are auditing any entity and you render audit service and non-audit service, you need to actually disclose it. Then Rule 4 talks about what we call the notar, though this Rule 4 has been revoked as we speak. Rule 5 talks about the submission of final statements, financial statements, for which external auditors expresses opinion other than unqualified opinion. So anytime you issued a qualified opinion, you are expected to submit a copy of that opinion a copy of that account with the FRCN. Then Rule 6 talks about non-submission of the financial statements within the stipulated time as required by the Act. So you are also expected to submit, particularly this applies to entities that are actually quoted, right? Every entity that are quoted, their audited account, a copy of which was submitted with the FRCN. Then Rule 7 talks about other national disclosures, among which includes the value-added statements and the likes that you are expected to make disclosure on your account. Then Rule 8 talks about the functional and presentation currency. What is the standard, accounting standard that relates to this?
IAS 21.
IAS what?
21.
21. All right. So that is with respect to FRCN. Please take your time to go through the documents that will be shared later on. Oh, sorry. So the next one is the SEC. SEC is the main regulatory body for Nigerian capital markets. It is supervised by the Federal Ministry of Finance. And the Nigerian Stock Exchange Market is a privately owned and self-regulating, but the SEC maintains surveillance over it with the mandate of ensuring orderly and equitable dealings in security and protected markets. So not every company is actually subjected to this. Only those whose shares and other securities are traded on the stock exchange markets. Then this is also, I've explained most of this before, the CBN, who discharges their functions to entities that operate within that sector. And for you to understand fully what should be the responsibility of CBN, how it impacts or it could impact the processes of your clients, and the various prudential guidelines and the rights to even issuing those prudential guidelines, you might need to see the CBN Act and the various prudential guidelines that is issued from time to time, right? What is the act that relates to entities operating in the bank and other financial industry? What is the act that relates to entities operating in the finance, banking, and other financial industry?
BOFIA.
BOFIA, very good. So we also have the Anti-Money Laundering Act. How does it impact the processes of your clients? You know that every company is actually, an individual is also actually expected to comply with the Anti-Money Laundering Act in Nigeria. So if you are an auditor or an accountant and you've not been abreast of this information, or you don't even know what obligations or what responsibility should be that of your clients, please take your time to going through this act to ensuring that all your audit process are discharged within in strict adherence to the relevant provisions of this act. So I've provided a number of that because of time. Time is really far spent. Then we have what we call the non-compliance with law and regulations. This is very much like an international provisions that imposes responsibility on all accountants and auditors or anybody operating in that capacity to ensuring that they comply and drive compliance with laws and regulations. So we call it NUCLA or NUCLA is defined as an act of omission, act of omission or commission, intentional or unintentional, committed by a client or employer, including by management or by others working for or under the direction of the client or employer. So if you work with a client and you are supporting or aiding the client in violating the laws, then it means you have violated the provisions of these acts, right? So you are encouraged, for you to drive compliance with this law, you are encouraged to ensure that you know the law itself, you know what the law expects of its subjects, and you encourage the subject of those laws that are your own clients in or your own employer in adhering to all relevant provisions. So this is what we expect you to know. This is just a few among the so many other statutory regulations or provisions that you are expected to adhere to. By way of rephrasing what we have said thus far, we look at the regulatory frameworks. We emphasize that regulatory frameworks are not there for beautification's sake, but they are there to serve as guidance to its subjects, right? And as auditors, the laws as mandate us to drive in this compliance. there are the standards that also regulate how we should discharge our work, that is at 250, has also further buttressed the fact that we have an obligation to discharging in this regard. We did consider the provisions of CAMA. We look at the provisions of the Insurance Act or NICON guidelines, and we emphasize the need why auditors need to fully adhere to all of this. We consider the international standard of auditing. We cited one that has a real impact. We look at the provisions of FRCN and why FRCN acts a supervisory function on accountants in practice. We also look at the SEC. We made mention of the prudential guidelines, which is an instrument used by CBN to regulate its subjects. And we consider that the Anti-Money Laundering Act and also the Non-Compliance with Law and Regulation Act. So these are some of the things we should know. There are still so many more. We didn't talk about anything relating to oil and gas sector that's peculiar to their processes because of time. So if you are working in that sector, you need to find laws that will have impact on that and be sure that you are abreast of those information and you are driving compliance. Law and Constitution of Nigeria is also one of those things you need to be abreast of, particularly as relating to state enactments that imposes certain responsibility on any company in particular. Please, one of the ways we can actually make this profession very, very reputable and noble for us all is that we are not just trained to be accountants, but we display the dexterity and the prowess expected of us as professionals and discharge all our responsibility with a good sense of prudency. I hope with this, we have been able to enlighten you on what you need to know and how you need to acquire the relevant skills that will put you on a pedestal for due compensation from your employer and respect by your own client. I will also, before I draw the curtain, I will also expect that everybody on this training today has also registered their attendance using the Google link that have been shared. Please, if you have not done that, scroll through the chat box and use the link and ensure that you are registered. Certificate of attendance will only be awarded to participants provided they have at least 90% attendance. We want to be sure that we don't just encourage people to say, oh, I will listen to the video. No, be here. Ask questions, because when you are watching the video, you might not be privileged to ask live questions where you so have. So please, let's encourage ourselves. And for the sake of those who have been driving for or soliciting for others to join, because of the pressure, we actually open the link again. The link is still open. Please, you can attract your other colleagues. People have been engaging me that what we share is so rich enough to be limited to these participants alone. So you can use that link, send it to whoever that you think will be willing and interested to join in this forum. And I pray that God will continue to protect us, crown all our efforts with success, and grant us wonderful opportunities in Jesus' name. Any question? Any question, please? While we are waiting question, don't forget, same time tomorrow, we'll be having another section. And on Sunday, we'll be having the final section for this week. Please ask your question if you have any, or if you have any contributions or suggestions you want to give to us as a way to serving you better, please do. While we await the question also, don't forget this particular training session has been piloted by KCP. KCP is a firm of professional accountants. We render audit services, audit and assurance services, tax advisory services, training services, regulatory services, HR recruitment services and consulting, and account support services. Should you have business for us, do not hesitate to call on us. Maybe your employer or your company, you need training on various accounting topical issues or audit issues or tax issues. We'll be willing to offer the in-house training for you. Should you have any business contacts for us, you know of clients, of relatives that need the service of a firm like ours, and you feel comfortable linking us with them, we'll be glad to have in touch too. Any question, please? Any question? All right, so in the absence of any question, I want to say a big thank you for everyone who has attended this section today. We hope that it has been a wonderful experience for you. We still have more in stock and we'll be dishing it out in the course of time. So thank you everyone, and have a very pleasant evening. Please, all the materials we are sharing, don't just put it in your archive. Please go through them. Engage us or any of your colleagues on areas you might desire clarifications. All right, so somebody has reshared the link. Please, if you have not registered for this, use the link and ensure you complete the registration. In our subsequent class, there will be a question and answer session there from tomorrow. Please be prepared. Ensure that if you're using your laptop to listening, let it be in a good form, because the question and answer will be automated. And if you're using your phone, just ensure that it is in the right function. We'll be giving awarding marks and some other bonuses for those who perform very well in questioning. So we'll watch out for the questions and the gifts that may come with it. All right, so any question in the next 1-2 minutes? I want to draw up the curtain for tonight. Any question? Any additions, any clarifications? All right. Thank you, everyone. Enjoy the rest of the night. God bless you. Good night, everybody.